doesn't mean that the attorney isn't doing their job. I don't see a basis on which to take Mr. Brown off this case. Now, if you want to hire your own attorney, you can go ahead and hire your own attorney.
Okay, that'll be the next procedure that I'll try to do then.
So you're going to try to hire your attorney. How much time you need to do that?
I'm not sure, sir. I don't know.
Well, I got to set a date. How much time do you need? You don't like the best that Washington County may have to offer, and now you want to hire somebody else. How much time do you need?
Well, first of all, I got to try to come up with some money.
Oh.
Okay. Then second of all, I have to have someone to help me find an attorney.
Mm-hmm.
Is it a such thing as a pro bono attorney?
A what?
I may not be pronouncing that correctly, but there's a lot of credential work there. Pro bono. Pro bono.
Right out of the gate, the judge isn't just asking a scheduling question. This is a credibility test. When a defendant wants to fire a public defender, the court has to determine whether there's a legitimate breakdown in communication or just delay tactics. And notice the subtle flex, the best that county may have to offer. That's the judge signaling confidence in appointed counsel. So the real question is this about legal strategy or control?
Attorney.
A pro bono attorney. Meaning one that is a good attorney that you're not paying for?
Yeah.
That's what you want?
Basically, that's what I'm saying. Yeah.
Okay, so you realize standing next to you is one of the best that you're not paying for right now. Yeah, no. I'm shocked.
I wouldn't challenge that.
You would?
I wouldn't challenge that. I said, I'm not saying he's not. I'm just saying.
Oh, so now you're not saying he's not.
I've said what I've said.
Mm-hmm.
And
so to the extent that is even a proper motion to permit withdrawal of the public defender's office in Mr. Brown, that motion's denied. I don't see a basis upon which to do it.
Your Honor, what I'm going to ask to do is to adjourn this for 1 week. So that
1 week?
And here it is, the pruno attorney moment. He's clearly trying to say pro bono, meaning free legal services. But here's the irony. He's already standing next to a publicly funded defense attorney. That is the pro bono equivalent in criminal court. This exchange may sound humorous, but legally it matters. Courts don't grant new counsel just because someone hopes for a different free option.
Yeah, so that my client and I can have a chance to talk and find out the nature of his discontent.
Our cause conference will be adjourned. When we guys what, the 6th? June 6th, 2024. 9 a.m. as your invite indicates. Bond will continue. All right, Mr. Edwards, I'm going to make a suggestion to you before you take those off. I'm going to make a suggestion to you.
yes, sir.
Rather than doing a whole lot of thinking yourself, when Mr. Brown comes and talks to you, maybe you ought to listen to him. And then if you have questions and you may not understand something he's saying, you should probably just ask it. And then you'd have probably a better understanding of what's going on, and we don't have to go through this again. Thank you. Have a great day.
Your Honor, this is day and time set for PCC. We respectfully request that to set this for exam.
I have a community corrections bond violation.
Yes, Your Honor, I have discussed that matter with my client, and we are also ready to address that as well with the court.
Why don't you address that before I set it for anything?
Pardon me, Your Honor?
Why don't you address that before I set it for anything?
Absolutely, Your Honor. So I did speak about this with Mr. Obich. He represented to me that he did not report to community corrections since his release from the jail. Upon his release from the jail, he did not receive any bond violation or bond paperwork or anything like that, and was not aware that he had to report. Upon finding out that he did have to report last Thursday, May 23rd, he states that he called community corrections and spoke to someone.
From what date is he saying he didn't know he had to report?
When he was released from the jail, I believe on the 11th, Your Honor, is that correct?
I believe it was a Saturday. No. On the 11th of May?
I believe so, Your Honor.
And there's the ruling. Motion denied. Legally speaking, a defendant must show good cause to replace appointed counsel. conflict of interest, total breakdown in communication, or incompetence. Simply feeling dissatisfied doesn't meet that threshold. Notice how the judge subtly pins him down on his wording before ruling. That's courtroom precision. Words matter here.
That he did, upon his release, didn't receive paperwork and then had not reported at all until May 23rd. He states that he did call and speak to someone. He does not recall the name. And they told him to just keep calling his number every day, which his number is 5. And since last Thursday.
So why did he start calling on the 23rd?
Because I called him and told him that a warrant may be on its way and to get in contact with community corrections immediately, which he did. He represented to me that he did call community corrections. They advised him to continue calling every day with his number. He represents to me that he has been doing so every day, that they have been open since last Thursday. He states to me that his number is 5 and that number 5 has not been called since last.
That right there is judicial diplomacy. The judge just gave him a roadmap. Listen first, ask questions second. This is actually solid courtroom survival advice. A lot of defendants sabotage their own defense by assuming instead of clarifying. Let me ask you, do you think this is confusion or resistance to authority?
Last Thursday, he did also state that he is 1,000% ready, willing, and able to test. He is willing to do so right now. He just did not realize that upon his release from the jail that he had to go do so. So he actually is.
So he was testing before.
Yes. And then he
put in jail.
Yes, Your Honor.
Comes out of jail. So explain to me the rationale of why testing wouldn't have continued.
Because he has another pending case, Your Honor, in circuit court with other counsel. And to my understanding, bond conditions have changed in that case.
Had what?
Had changed in that case. And Mr. Obich represents to me that he thought they had changed.
And now the stakes just jumped. A community corrections bond violation isn't minor. It can land someone right back in custody. Reporting requirements are not optional, even if paperwork confusion exists. Judges tend to have very little patience for "I didn't know" arguments, especially when prior testing was already part of bond conditions.
Changed in this case as well, and that he was no longer required to test, but he is ready to test today.
So in a circuit court case, he's not required to test anymore?
That's what he states to me. Is that
Can I speak? So I'm confused because I have these different court dates, but they're trying to put it under a global resolution. So I don't understand where and when or what I'm supposed to follow on, because sometimes I go to this court and it's everything's under a global resolution. So I'm really confused on where I even begin to what I'm supposed to do.
Why was he remanded on the circuit court case?
I don't know, Your Honor. He has private counsel.
It's positive for being tested.
Yeah.
And he is required to test in his circuit court. His conditions have not changed. He has the exact same bond violation. He gets bond violation report in that file that he has in this case.
I was unaware that, Your Honor. He does have private counsel in that matter. I was just told that his bond conditions had been changed by Judge Slay at some time.
And here's the unraveling moment. The global resolution confusion falls apart once the judge confirms the bond conditions never changed. A positive test in circuit court, identical violation report here, that's a pattern, not paperwork confusion. When multiple courts are involved, the responsibility to comply doesn't disappear. So what do you think? Genuine misunderstanding, or hoping the overlap would blur accountability?
Mr. Obich states to me that when he was incarcerated after his remand, he had another court date, and when he was released on that case, he did not understand that he was supposed to report to community corrections from his release from the jail.
When was that?
That his release from the jail, Your Honor?
Yeah.
I believe May 11th. Mr. Obich does not remember when his last court date was in circuit court, so I can't speak to that. Our request at this time, if Your Honor would allow, is to allow him to go test right now. He represents to me that he would test clean, and we would ask the court to re-refer him to community corrections. And frankly, Mr. Obich did say he would be willing to go there every day to test if need be. He's been appearing for court regularly, he hasn't missed a court date, and he just asked that the court allow him to go test.
When is he supposed to next appear in front of Judge Slay?
28.
June 28th.